As an amendment to the amendment that I proposed earlier, may I propose at the end of section 4, it is essentially designed a protection for third parties who may be now included in the investigation under the new amendments, which were not actually allowed before the amendment. These amendments will have been enacted. So the new language that I propose is this: provided that this act shall have prospective operation and shall not apply to deposits and investments made allegedly by holders of related accounts prior to the effectivity of this act. That way, because of the related accounts, that is what we are worried about, that did not exist before.
Refers to persons who have allegedly related accounts to the principal account holder. In other words, for a person deposits his money in the name of one. Now, this bill now says, in effect, that one will also be subject to investigation. Now, a law to be constitutional should have prospective operation. A law cannot have, we cannot pass a law which is ipso facto. All these people who may be targeted by AMLA as supposedly holding accounts for money launderers will now be affected. Well, the Constitution says that laws should be prospective. We can file an ex post facto law, and they are subject also to criminal prosecution because there are penal provisions. For instance, somebody is a plunderer or whatever, he is now subject to a penal provision. Now, in our desire to protect or to strengthen our anti-money laundering law, and the rule on privacy, two constitutional provisions are incorporated in the bill, and that it will be enforced, and that they are part of the measure, and they are incorporated by reference as part of the measure. So that's the protection. Now, if we don't give a protection to persons who may have been having their accounts, now what happens to them? Are we going to say that for the sake of the anti-money laundering law and because of AMLA, we just run roughshod over them? I mean, I don't think it's fair. That's all I want to emphasize here. We are obligated also to protect them. This is the case, and I suppose that I don't know whether Senator Marcos shares my position.
The simple principle that it cannot be retroactive is, I think, applies here, because those related accounts that were created, used, etc., previous to these new amendments should not be, the amendments that we intend to pass should not apply to what had happened before, precisely because of that principle. So that is why we, so as not to hamper the investigations of the AMLA, we are this provision is naming specifically third parties, because the principals who are the principal targets of the investigation are not being protected under this provision. It is those third parties who previously could not be investigated, but under these new amendments can now be investigated, that those investigations cannot be applied to them, therefore not retroactively applied. So that is precisely the same point that the reasoning behind the proposed amendment.
Mr. President, to accept such a proposal would defeat the very purpose of the law.
Counter into it, and it seems to be counter precisely to that principle that we are applying these new procedures to those third parties to which such procedures could not have been applied before. Therefore, the interpretation that it is a retroactive application of the amendment.
When they do the action to inquire into an account with the court's permission, ex parte, will be done in the present and not in the past.
But this, Mr. President, this allows now the AMLAC to investigate or to apply this ex parte application for freeze order to these accounts. When beforehand, without these new amendments, should they be passed, we could not do that. That is why the interpretation, as I said, is a retroactive application. That is why we are trying to protect those third parties that will be affected by the inclusion of this provision.
Now, we have to protect the 90. We cannot say that bahala na sila. So this is what we are saying, that the 90 who are innocent must be extended protection. So, I will not quote anymore what Senator Marcos has stated, but if I will just quote what is now in the law, it will read, provided that this provision shall not apply to deposits and investments made by alleged related account holders prior to the effectivity of this act. In that case, the supposed what's this now? Those account holders are also given some protection. This is, we have to do this, otherwise we cannot make, there are penal provisions here. Not in the law itself, but in the related laws.
Mr. President, perhaps to move the discussion forward. If you, Mr. President, the proposal as it stands now stands made prior to the effectivity of these amendments. If we can change that to that prior to the effectivity of the AMLA law, i.e., the original AMLA law 2001. Would that then be acceptable? The amendments that are being proposed and the capability of AMLA to investigate.
But Mr. President, what if the money trail, because the point here is to follow the money trail, and what if the money trail goes to an account and accounts that were prior to the passage of the AMLA law?
Money laundering wasn't a crime then, so we cannot.
Yes, but it is now. And
precisely.
Therefore,
so after.
No, Mr. President, that would effectively shackle them from pursuing the money trail.
So aren't they already shackled by the Constitution in applying the AMLA law retroactively anyway?
I would not see it that way. I would see it that in fact, the Constitution safeguards the rights of the individuals.
Precisely.
Through a procedural and statutory requirements for safeguarding their liberties, Mr. President.
So maybe investigations could not be undertaken before the 2001 until when records started to be kept.
Mr. President, is my distinguished colleague making an amendment to his?
Yes, I'm trying to find a compromise for us to so that we can move the discussion.
Then I'm sorry. What exactly would then be a phraseology?
The phraseology will then be, provided that this act shall have prospective operation and shall not apply to deposits and investments made allegedly by holders of related accounts prior to the effectivity, or if you want, of the AMLA law.